The NDAA has been called the death of our Republican form of government. That acronym refers to the National Defense Authorization Act of 2012, which contains a provision allowing the president to order the indefinite military detention of anyone accused of offering substantial support to al-Qaeda or associated forces. The measure does not define critical terms. For instance, what groups would be considered associated forces? And it applies to U.S. citizens who, under the ambiguous and expansive terms of that measure, could be detained by the military on U.S. soil until what the measure calls the end of hostilities, which in the open-ended war on terror could mean forever. According to the Obama administration's spokesman, the NDAA could be used to imprison war correspondents or other journalists who cover terrorism-related issues. The NDAA has no parallel in American history. In fact, it is without precedent in the history of Anglo-Saxon law since the Magna Carta was signed in 2015. Perhaps the closest historical kindred to the NDAA would be Article 58 of the Soviet Criminal Code, which allows for arrest and summary imprisonment of anyone suspected of working to undermine the Soviet state. Journalist and activist Tangerine Bolen is one of 8 plaintiffs in a lawsuit against the NDAA. Although she voted for Obama, she describes herself as terrified by the arbitrary powers that the president and his advisors can now exercise in the name of fighting terrorism. Ms. Bolen, we are very grateful that you can join us to discuss this important subject today. Could you introduce to our audience yourself and the other plaintiffs in the lawsuit against the NDAA and explain why you decided to file the suit?
Absolutely. So I'm Tangerine Bolen, and my co-plaintiffs in the suit against the National Defense Authorization Act, and our lawsuit is called Hedges v. Obama. My co-plaintiffs are Chris Hedges, of course, who originally filed the suit, Noam Chomsky, Dan Ellsberg, Icelandic parliamentarian Birgitta Jonsdottir, Kai Wargala, and New York-based journalist Alexa O'Brien. And why did I decide to file this multi-plaintiff suit? I was, terrified of what my government was becoming in the wake of 9/11. And when the NDAA was passed in 2012, there was a provision with a paragraph in it that basically could cover anyone, journalists, advocates, civil liberties advocates, activists, and essentially allow any of us to be indefinitely detained at whim based on secret evidence and by the military. So I felt particularly in danger, and so did my co-plaintiffs, and so they were happy to join suit.
Now, didn't a federal judge issue a permanent injunction against the NDAA several months ago? And if so, how did the matter wind up back in court?
Oh, so yes, we had an astounding win, first in May and then in August. In May, we were granted a temporary injunction while the judge continued to look at the merits of the case. And then in August, she ruled for a permanent injunction against this provision. It's called Section 1021. She actually declared it facially unconstitutional, which is the strongest ruling any judge anywhere could have handed down to us, and agreed with us that it contravened both the First and Fifth Amendments. How it ended up back in court is that despite President Obama issuing a signing statement in January of 2012 saying he didn't really want these powers, within 24 hours, the administration appealed and even went for an emergency stay on our injunction, claiming that irreparable harm would be incurred if they lost these extremely broad, sweeping, and unchecked powers of indefinite detention. So we were just in court on February 6th this year to hear that appeal.
And now, in defending the NDAA, South Carolina Republican Senator Lindsey Graham insisted that it is appropriate to withhold due process protections from U.S. citizens who adhere to the enemy in a time of war. What's wrong with the argument that Senator Graham has?
There are so many things wrong with that, I'm not sure where to begin. Obviously, we have the United States Constitution, which is one of the strongest civilizing rule of law documents in the history of humanity. There's a reason we abide by the United States Constitution. All people in this nation are granted due process. And no, it's not okay to declare someone either an enemy of the state or a co-belligerent or an associated force or a terrorist without presenting any evidence or having to present any evidence to anyone, and the military picking them up off the streets and holding them indefinitely where that person has no access to an attorney, to family, to advocate on their behalf. You know, this government seems to see boogeymen in every corner. And while obviously there's legitimate terrorists to worry about, and we want our government to have an array of tools to combat that fact, that doesn't mean we abandon the United States Constitution. So.
Well, I want to get into the distinction between enemies and belligerents in a moment, but given the recent memo that was released in talking about the execution of American citizens using drones and the policy around that, and now talk of setting up so-called assassination tribunals, how does that impact the NDAA and the average American?
Well, it's all interrelated. In fact, there are sort of nascent theories circulating that the NDAA is to be used for a number of things, including legalizing these drone assassinations. So, and all of it is part of a larger pattern of this steady and profound erosion of the rule of law itself and perversion of the rule of law. It's sort of shocking because obviously, President Obama is a constitutional lawyer, yet he seems to have no compunction whatsoever about making the rule of law as he sees fit in this ongoing war on terror. And one of the issues with that, I think that is most astounding and terrifying, is that this, quote, war has no geographic and no temporal boundaries. So in the past, when nation states were at war, there was some end in sight, hopefully, and even if it took years, there was an end in sight. There were
Tangerine, let me just jump in real quick, because there's also no declaration of war been formally voted on.
Right. And so the NDAA actually seems to be a very strategic and effective way for this administration and even the past administration to legalize things that they've been doing that they should not have been doing in the wake of 9/11. We can get into that later because it's a pretty big part of our case and really critical that the public understand what the United States government is trying to do with this law.
Now, in your recent essay describing your lawsuit, you offered a pointed distinction between enemies and belligerents. Why is that distinction so important, and is it possible for a U.S. citizen to be designated a belligerent by merely exercising rights under the First Amendment?
Well, yeah, under the 2012 NDAA Section 1021, it appears to be quite possible, and that's why we filed suit. There's a difference between declared enemy of the state, which has been settled in case law, and a co-belligerent, or a, quote, associated force providing, quote, substantial support. Those terms are not defined anywhere in case law. They're not defined in the NDAA itself. And they essentially provide for a covered persons definition that is sweeping and unchecked. Anyone could fall under that definition. Is our government going to pick people up off the streets tomorrow because they criticize it? No, probably not. But people like me, who have tried to help Julian Assange in WikiLeaks, Birgitta Janstadter, who actually produced the collateral murder video that shows U.S. war crimes, that's a different story. I mean, we're a significant threat when we continue to buck the dominant narrative here. And yes, that provision can cover people like us. And in fact, in March of last year, the DOJ attorneys actually refused to state on the record that people like us would not be indefinitely detained for exercising our First Amendment rights.
Tangerine, some defenders of the NDAA insist that the abuses you describe are entirely hypothetical. Is that the case?
Absolutely not. And we 7 plaintiffs were all granted standing in this case. That's because not only were we terrified, legitimately so, of this provision, but each of us had, in effect, changed our activities and behavior because of the NDAA. It's interesting because Dan Ellsberg has spoken about it, and he's talked about the warrantless wiretapping, the fact that both administrations are defending wiretapping journalists when they talk to, quote, unquote, terrorists. And, all of us have changed our activities because we know that at least some of the time, some of us are monitored. So we don't feel like we can engage in our First Amendment activities safely at this point. And secondly, you probably know that there's the example of the Yemeni, the journalist who's imprisoned in Yemen. President Obama has made sure that he has remained imprisoned. The administration has accused him of being engaged with terrorists, but it's quite clear, Jeremy Scahill has done amazing investigative work on this. It's quite clear he's reporting about these terrorists. He became embedded with them so that he could really tell the story of what was going on. He provided a platform for people our government considers unsavory, and President Obama has made sure that he remains imprisoned in Yemen.
Now, is there a double standard between journalists like you just spoke of and, for instance, journalists in the past who've actually sat down with Osama bin Laden and interviewed him on national television? What's the difference here?
Well, that's a good question. And that's what we have brought up in court. And that is what the DOJ attorneys refuse to actually answer. They insist on this right to have this enormous gray area that they define for themselves at whim. So, Chris Hedges has traveled the world. He has traveled with and interviewed terrorists of all sorts. And, the government has even claimed that war correspondents could be indefinitely detained under the NDAA. So no one knows. And our case is very conservative. We're simply asking the government to define its terms, to abide within the bounds of the U.S. Constitution, and to make sure they're not trampling the First and Fifth Amendments.
Now, indefinite detention is not the only extraordinary power claimed by the president in the name of the war on terror. The case of Anwar al-Awlaki involved a prominent U.S. citizen dissident who wasn't merely detained, he was executed by way of a drone strike. Is the United States becoming a kind of country where summary execution of dissidents is an accepted policy?
Well, I have a bit of a problem with the way you just framed that, because he was technically designated a terrorist, and given his support of jihadist activities, he is less in a gray area. It's a little more black and white with him, but that does not mean that drone assassinations are okay. We have been a paragon of justice, of democracy for a couple hundred years. And for us to turn around and for our president to say that it's fine to assassinate people because they're on a list of people, we call terrorists, I just think that anyone, anywhere deserves and needs due process. And if we don't adhere to those standards, I don't know what would happen. It's very scary.
Now, you and several of your fellow plaintiffs are self-described progressives who are concerned about the ongoing destruction of the Bill of Rights. Have you received any support from conservatives and libertarians who share your concerns about the preservation of the constitutional government?
Absolutely. In fact, there's a transpartisan coalition that backs our lawsuit. We've had about 25 groups file an amicus brief on our behalf. They were all right-leaning and far-right libertarian. And we have a couple, the BORDC, Bill of Rights Defense Committee, and 10th Amendment Center, which are libertarian-leaning. They both support us as well. So this is a nonpartisan issue, actually. And anyone who is, willing to look at the facts and the truth of what is happening essentially supports this case.
Now, what do you say to the people that try to frame this into a partisan issue?
Oh, gosh. I think I've been fortunate to not encounter that too much, because anyone who's paying attention doesn't see it as a partisan issue at all. I think one group that did try to frame it sort of in a partisan manner was John McCain and Lindsey Graham actually filed to have argument time in our court case on February 6th. And they were granted that time, which is really strange, because they claim to speak on behalf of the Senate body. And obviously they don't speak on behalf of my Senator Ron Wyden, who is categorically against indefinite detention. So they may have actually tried to make it nonpartisan. But there are a lot of politics at play here, and a lot of power plays. There's the Obama administration working really hard to maintain this radical executive power to assassinate people and indefinitely detain them, and there's Congress trying to wrangle some of that power back from the executive. So here we are at the center of that fight, and all we're trying to do is force our government to abide by the United States Constitution. Now,
in your recent op-ed column, you acknowledged that you've been a supporter of President Obama. Do you have any idea why he and his administration have fought so tenaciously to preserve the NDAA?
Yeah, I have a couple theories on that. And I was a supporter. I did vote for him in 2008. I voted no confidence in 2012. I can't vote for him at this point. But, the Department of Justice in our case has continually, and I believe strategically, tried to conflate two very distinct laws. The 2001 authorization for use of military force, which allowed the Bush administration to go after a very narrow class of people. And it was just those who had participated in the 9/11 attacks or planned them, or members of Al-Qaeda or the Taliban. Very, very narrow parameters of indefinite detention on that law. I think the 2012 NDAA is essentially a massive retroactive CYA for the fact that both administrations have been applying the AUMF quite broadly, not within those parameters, which would be illegal. So I think Obama has tremendous incentive to allow his Department of Justice to strategically conflate the powers of these two laws, pull the wool over the eyes of everyone, the judiciary, the public, et cetera, and make sure that we don't understand that the government did not have these powers ever, and they've just arbitrarily granted themselves those powers through Congress in 2012. So, and I also think it's a way to go after, a very effective way to go after Julian Assange and WikiLeaks, and to prevent any future embarrassments or trouble via cyber whistleblowing platforms.